Cases come to the Supreme Court almost exclusively from two sources. A decision of a state Supreme Court that involves a federal question, constitutional or statutory, and cases from the federal courts of appeals that raise a question that the court decides is worthy of further review, or in a few instances that have to be heard by the Supreme Court by reason of appeal. The court system is hierarchical with three tiers in the structure. So there's a trial court and a court of appeals, and then ultimately a Supreme Court. The facts have been settled by the trial court and will not be upset unless there's a blatant or so-called clear error. The federal circuit courts and the intermediate courts of appeals in the states are reviewing decisions of the trial courts, and there the review is de novo, meaning to say without any deference to the trial court. The Court of Appeals makes its own decision about what the law means. The losing party in any court of appeals or in a state Supreme Court may petition for further review in the Supreme Court. The way in which one requests review by the court is to petition for a writ of certiorari. That is a writ that would be directed to the lower court to send the record to the Supreme Court. Typically, the justices receive a recommendation from their law clerks, or in the last few decades, there has been a certiorari pool in which one law clerk from one of the justices' chambers writes a memorandum that is sent to all of the justices in the pool. The Supreme Court decides whether to accept a case for review, whether to grant a petition for certiorari by a vote of its members. It takes 4 votes out of the 9 for a petition to be granted. The court is now receiving upwards of 8,000 petitions for review every year, and it is hearing about 80 cases a year. So that's about 1% of the requests that it receives. Of the 80 or so cases that the Supreme Court hears every year, about a quarter are cases raising constitutional issues, and some of those are very important or very controversial. The other 60 cases that the court hears each year may be relatively routine statutory questions in which different courts of appeals have come to different conclusions, and the Supreme Court needs to resolve the conflict so that people know what the law means and what their rights and obligations are.